Judge Eleanor Prescott's pen had just touched the order stripping him of control when the doors at the back of the courtroom swung open. Willa Brooks Calder walked down the aisle between two rows of frozen faces, her heels steady on the wood floor, dark lawyer's suit, a briefcase in her hand that no one in that room had ever seen. Every head turned. 15 years ago, Mason Calder had pulled her out of a bus shelter in the rain and given her a home. Today, he sat there accused of stealing $180 million minutes from losing everything. Willa never once looked at him. This time, had she come to save him or to end it? Baltimore in the rain smelled like diesel and salt. Mason Calder finished his shift on the container piers at 11 at night, walked the 4 blocks to the bus stop on Bruning Highway, and found someone already sitting in it. She was maybe 18, soaked through a canvas bag pinned between her ankles, like it was worth defending. She did not ask him for money. That was the first thing he noticed. Everyone at that hour asked for money. She just moved over on the bench to make room for him, as if the shelter were an apartment, and she was being polite about it. "Bus stopped running at 10, Mason said. "I know," she answered. He sat down anyway. His jacket was wet through at the shoulders, and his hands were split at the knuckles from 3 days of hooking chains in cold weather. He was a widower with a son at home and $41 in his checking account, and he had no business talking to anyone. "You got somewhere?" he asked. She said nothing, which was an answer. Her name was Willa Brooks. She had aged out of the system in March, which is the polite way of saying the state had stopped being responsible for her on a Tuesday, and after that, nobody was. She had been sleeping in that shelter for 11 days. She told him this the way a person reads a shipping manifest flat, in order no editorial. Mason did not offer her a home that night. He was not a fool, and neither was she. He walked her to the district station on Fayette Street, sat in a plastic chair beside her for 2 hours, and made a report. He gave a patrol sergeant his name, his employer, his address, and his son's name. He asked what the legal path looked like for a woman of 18 who had no one. The sergeant told him the legal path was that there wasn't one. Once you were of age, you were nobody's problem. Then, "Make me the problem," Mason said. It took 5 months. Fingerprinting a background check, a home inspection by a caseworker who counted the beds and looked in the refrigerator and asked Mason's son whether he had been asked or told about this arrangement. Adult adoption is a strange, quiet thing in Maryland. No fanfare, no visitation orders, nothing but a clerk stamping a piece of paper that says, "Two people who are not related are now, in the eyes of the state, permanently related." Mason's son was named Gavin. He was 19, working nights at an auto parts warehouse, and for the first 2 months, he barely spoke to her. His mother had been dead 4 years. He had watched his father come home gray in the face every evening and go out again every morning, and now his father had brought home someone else to feed. The thaw happened in a garage. Mason had rented a bay off Holabird Avenue for $150 a month, and in it he kept a beat-to-hell box truck and a folding table with a phone on it. He had one idea. The freight terminals were losing money on the last mile on the short, ugly hauls between rail yard and warehouse that the big carriers considered beneath them. Mason knew every gate and every yardmaster on that waterfront by first name. He thought he could run those hauls cheaper than anyone alive. Gavin drove. Willa answered the phone. That was the entire company for the first 18 months. A truck, a table, and 3 people who slept in shifts. Willa was the one who read the contracts. She was 19 the first time she caught an error, and 20 the second time, and by the third time, Mason had stopped checking behind her. She would sit at the folding table under a work lamp with a shipping agreement and a dictionary, and she would go through it line by line by line until she reached the end. Mason told her once, "Never sign anything you haven't read to the last line." He said it the way a man says a thing he has learned by losing money. She took it the way a person takes a religion. Calder Harbor and Rail grew the way real companies grow slowly, and then, all at once. One truck became 6. 6 became a yard. The yard became a terminal lease, then 2, then a rail spur agreement that nobody thought a garage outfit could win. 15 years after a rented bay on Holabird Avenue, the company moved freight through 4 states, employed 1,100 people, and carried a valuation just under $900 million. Mason kept his office on the 2nd floor of the terminal building above the loading floor where he could hear the trucks. He never moved to the tower downtown. He wore the same coat. The day the adoption papers cleared all those years ago, he had done 2 things. The first was that he took the spare key to the row house on Dillon Street, off his ring, put it in Willa's palm, and closed her fingers over it. He did not make a speech. He said, "In this house, nobody gets left out in the rain." Then he went to work. The second thing he did was walk to a storefront legal office in Highlandtown and pay $200 he did not have to a paralegal named June Holloway. June was 50, then sharp as a box cutter, and she asked him what exactly he wanted. Mason wanted a trust. Not for money, he had none. He wanted a document that said if anything ever happened to him, there would be an instrument with Willa's name on it that no one could argue with. June drafted it, filed it in the county register, and told him it was the strangest empty container she had ever built. The trust was funded with $100. June Holloway went on to become the company's first legal secretary, then the keeper of every original document Calder Harbor and Rail ever produced. She had a filing room in the terminal basement that she guarded like a bank vault. And every year, without being asked, she filed the renewal on that empty little trust because Mason had told her to, and because Mason had never once told her to stop. Willa went to law school on scholarship and a night job. She chose corporate law, which surprised no one who had watched her read a contract at a folding table. At her graduation, standing in a rented gown, she told her father she had chosen it because contracts were the only place she had ever seen where the truth was written down and stayed written down. Mason didn't understand the sentence. He remembered it anyway. Money changes what a boardroom is for. When Calder Harbor and Rail took outside capital to buy the rail spur, it also took on a board, and the board took on a chairman. His name was Barton Kingsley. He had silver hair, a Wharton pedigree, and a way of calling Mason our founder that made it sound like a museum exhibit. Barton had been chairman for 6 years, and for 6 years he had watched a former dock worker refuse to sell. The offers came in twice a year. Every one of them was refused. Mason's reasoning never changed and never persuaded anyone he had promised the terminal crews that the company would not be broken into pieces and sold off, and he intended to keep that promise for as long as he was breathing. To the board, this was sentiment. To Barton Kingsley, it was $900 million sitting in a warehouse gathering rust. The buyer who would not go away was a private capital fund called Van Dorn Meridian. Its chief executive was a woman named Cassandra Van Dorn, who did not fly to Baltimore for meetings. People flew to her. She had been assembling a freight corridor for 2 years' terminals in Norfolk, a rail interest in Pennsylvania, a warehouse network outside Chicago and Calder Harbor, and rail was the joint that connected all of it. Without it, she had a collection of expensive parts. With it, she had a machine. She had modeled the takeover 4 different ways. The cheapest was not to buy the company. It was to break its founder. The two of them never met in a place with a name. But over 11 months, Barton Kingsley began doing something that would later be very difficult to explain. He created a document queue in the chairman's office and routed board approvals through it, rather than through the founders on grounds of efficiency. He hired a records contractor named Wendell Frost to run it. In September, Frost was instructed to disable version logging on that queue for a period of 9 weeks, and in the same month, he was asked to assemble a consolidated packet of every instrument the founder had ever personally executed for what the chairman's office described as an audit readiness exercise. Board consent items came across Barton Kingsley's desk in stacks, after that tabbed and flagged, and he signed them the way men of his position signed things at the flag, without reading. Because reading is what you pay other people to do. He signed a great many things that year. He would remember exactly one of them much later, and by then, it would be far too late. The lawsuit was filed on the 9th of February. It came as a shareholder derivative action, which is a lawsuit brought in the company's own name against the man who built it, and it was drafted by a litigator named Julian Whitmore. Whitmore was 46, from a white shoe firm on Charles Street, and he had never lost a case that he had been allowed to choose. The complaint said that over the course of 9 years, Mason Calder had diverted $180 million in company assets through vendor contracts, terminal leases, and a chain of intermediary entities into a private trust he controlled. It said the trust had been established in secret. It said the trust benefited a single individual. It named her Willa Brooks Calder. Attached to the complaint was an emergency motion asking the circuit court to remove Mason Calder from operational control of the company pending resolution and to appoint an interim board slate. The interim slate was Barton Kingsley's. The story hit the wires within a day, and the story was better than the lawsuit. The lawsuit was accounting. The story was a man who had taken a homeless girl off the street and turned her into a laundry. That was the phrase one anchor used. Mason heard it from the loading floor on a television bolted above the dispatch window, standing in his coat with a cup of coffee he never drank. The men working the floor stopped moving. One of them reached up and turned it off, and nobody said anything. And Mason walked upstairs to his office and closed the door. The rain of that story got into everything. 15 years of an adoption, the caseworker, the background check, the key pressed into a palm, was reframed in 90 seconds as a long con. Reporters found the file number. They found the words adult adoption and made them sound like a loophole. They found a photograph of Willa at a bar association dinner in a black dress and ran it beside a stock photo of a bus shelter. Cassandra Van Dorn gave one interview. She was asked whether her fund had any interest in Calder Harbor and rail. She said her fund had an interest in governance and in companies that were run for shareholders rather than for families. She never raised her voice. She never had to. Within 2 weeks, 3 of the company's largest customers had suspended their contracts pending the outcome. The stock the employees held in their retirement plan lost a third of its value in 9 trading days. June Holloway came to Mason's office with a list of the documents the court would demand and asked him one question, which was whether the trust existed. "It exists," Mason said. "Does it hold $180 million? It holds $100. It's held $100 for 15 years. June looked at him for a long moment. Then she went downstairs to the basement, unlocked the filing room, and began to pull originals. The hearing was set for the 28th. From the day of filing, that gave them 19 days. Mason's own attorneys, a defense team assembled in a hurry and paid in advance because nobody extends credit to a man on the front page, told him the truth on the 4th day. They could not win the emergency motion. The plaintiffs had documents. The documents bore his signature. The signatures were in the opinion of 2 examiners, consistent with his hand. What they needed was not a defense attorney. What they needed was someone who could take a corporate trust instrument apart at the joints and show the court what it actually was, and who could do it fast enough to matter. There was exactly one lawyer alive who had that document, that history, and that specialty. Mason called her on the morning the complaint was served. The call went to voicemail. So did the second one, and the 4th, and the 9th. 3 days later, he drove to her apartment building in Federal Hill. Her name was still on the buzzer. Nobody answered it. A neighbor coming out with a bag of groceries said she had not seen her all week and asked in a voice that was trying very hard to be casual whether he was that Calder. Mason drove to her firm. The receptionist was polite in the way that people are polite when they have been instructed to be. Willa Brooks Calder was no longer with the firm as of the 11th. No, they could not say why. No, they could not forward a message. The managing partner was in meetings and would be in meetings for the foreseeable future. He sat in his truck in the parking garage for a long time. Gavin came up the stairs to his father's office 2 at a time on the 20th, still in his yard vest, and he did not sit down. "She's not answering me either," he said. 12 days. She's not answering anyone. Mason didn't look up from the papers on his desk. "You know what they're going to say," Gavin went on. "You know what it looks like. Her name is on that trust. She's a corporate lawyer. She got walked out of her own firm, and she didn't tell you. If she wanted to be found, she'd be found. She'd have a reason. Or she'd have $180 million. Gavin's voice cracked on it, and he hated himself for it, and he said it anyway. "You gave her everything, Dad, and when it's your turn, she's gone." Mason set the pen down. "She read every contract this company ever signed," he said. "Every one. She never once missed a line. You want to tell me she's the one who didn't read what she was signing?" Gavin had no answer for that. So he left. Barton Kingsley gave a statement to the press that weekend from the steps of the courthouse annex, where the light was better. He said that he had held out hope, as they all had, that Miss Brooks Calder would come forward and clear the air. He said her silence was regrettably the loudest thing anyone had heard in this entire matter. He said that when even a man's own daughter would not stand beside him, the board had a duty to act. It ran on every station in the Mid-Atlantic. Mason watched it alone in the row house on Dillon Street in the same front room where he had once put a key into a stranger's hand and told her nobody gets left out in the rain. His phone sat on the arm of the chair. 14 unanswered calls. He could pick it up and give a statement of his own. He could distance himself. His attorneys had already drafted the language. The trust was a nominal instrument. My daughter had no knowledge, no involvement, and no benefit. And every word of it was true, and all of it would have sounded on television like a man cutting a rope. He turned the phone face down. 19 days became 11. 11 became 4. She did not call, and on the morning of the 28th, Mason Calder put on the same coat he had worn on the piers and drove downtown to lose everything, still believing in a woman who had vanished. The courthouse steps on the morning of the 28th were a wall of cameras. Barton Kingsley crossed them slowly, because slowly is how you cross a thing you have arranged. He said that this was a sad day for a company he loved. He said the board had exhausted every private remedy. He said he took no pleasure in it. And then he stood there for 11 seconds longer than a man taking no pleasure in something would stand. Mason Calder went in through the parking level entrance in his coat, carrying nothing. Inside, Julian Whitmore had already laid his case out on the plaintiff's table like a surgeon laying out steel. 9 binders, each one tabbed in a different color. He did not open them. He did not need to yet. He simply let the room look at them. The first 2 days were procedural, and the procedural days were where Mason lost. Whitmore put on a documents examiner who had reviewed 41 instruments, vendor authorizations, terminal lease consents, intercompany transfer approvals, every one of them bearing Mason Calder's signature, every one of them routing value in increments too small to trigger an audit and too consistent to be accidental toward a chain of intermediary entities. The chain terminated in one place, a trust, filed in Baltimore City 15 years earlier, named for a beneficiary who was at the time of filing a woman who had been sleeping in a bus shelter. The examiner testified that the signatures were consistent with Mason's known hand, not forged, not simulated, consistent. Mason's own attorney stood up and asked the only question they had, which was whether consistent meant authentic. The examiner said that in his professional opinion the distinction was academic. The gallery laughed. Judge Eleanor Prescott did not, and she did not let them laugh twice, but the sound had already gotten into the room and stayed there. By the second afternoon, Calder Harbor and Rail's stock had lost half its value from its January close. 2 more customers suspended. The union local that worked the terminal floor issued a statement saying it had confidence in the men and women of the company, which is the statement you issue when you no longer have confidence in the man who runs it. Cassandra Van Dorn did not attend. She sent no one. Her fund issued a single line saying it was monitoring the situation with interest, and every analyst in the corridor understood exactly what that meant and priced it in. And every day, all through it, the seat behind Mason at the defense rail stayed empty. Gavin sat 2 rows back. He came every day. He did not speak to his father, and Mason did not turn around, and the space between them was the same space that had been in the row house on Dillon Street since the night Gavin had said she's gone and been unable to take it back. Then on the 5th day, the photograph ran. It was a still frame, time-stamped the 19th of February, taken from a security camera in the lobby of an office tower on Park Avenue. It showed Willa Brooks Calder walking out through a revolving door in a gray coat alone at 4:17 in the afternoon, 9 days before the hearing began. The building housed the New York offices of Van Dorn Meridian. The story wrote itself in under an hour. She had not vanished. She had gone to the buyer. The daughter had gone to the other side, and the timing was not ambiguous, and the caption under the photograph on every broadcast in the Mid-Atlantic asked the only question anyone in Baltimore was asking: what did she sell, and for how much? Mason saw it on a phone screen in a hallway outside courtroom 6, held up by an attorney who was trying to prepare him and could not make himself say the words. He looked at it for a long time. Then he handed the phone back and went into the courtroom and sat down and said nothing, and his lawyers understood that they were now defending a man who had decided not to defend himself. Julian Whitmore's closing on the emergency motion took 22 minutes. He did not argue accounting. Accounting was in the binders, and the binders had already done their work. What Whitmore argued was motive, and he built it with a craftsman's patience, and he built it out of an act of kindness. He said that no one disputed that Mason Calder had taken a young woman off the street. He said that this was on its face admirable, and that admirable acts were precisely what a sophisticated man would choose if he needed a vessel someone with no family, no assets, no history, and no one in the world who would ever ask her a hard question. He said the founder had not adopted a daughter. He had incorporated one. He put the trust instrument on the screen. 15 years old. Filed within weeks of the adoption. Beneficiary named. Settlor Mason Calder. Then he called Mason to the stand and asked him one question. Did you create a trust in the name of Willa Brooks Calder? Mason's attorneys had spent 2 days telling him what to say. There were 4 different answers, all of them true, all of them careful. Yes, he said. I did. That was the moment the room decided. Not the binders. The one word in the founder's own voice in the founder's own coat. Whitmore sat down without another question. He had gotten what he came for, and he was too good to gild it. Judge Eleanor Prescott took the recess. When she came back at 2, she said that she had reviewed the submissions that she found the plaintiffs had shown a likelihood of success on the merits sufficient to support interim relief, and that she was prepared to grant the motion removing Mason Calder from operational control of Calder Harbor and Rail, pending final resolution. Barton Kingsley did not smile. He had waited 6 years, and he intended to be a gentleman about the last 30 seconds of it. Judge Prescott reached for the order. Her pen touched the page, and the doors at the back of courtroom 6 swung open. Willa Brooks Calder came down the center aisle in a dark suit carrying a briefcase, and every head in that room turned, and the sound the gallery made was not a gasp, but something lower and uglier than that. She did not look at her father. Not once. She walked to the bar, set the briefcase down, and addressed the bench. "Your Honor, Willa Brooks Calder, entering my appearance as counsel of record for the defendant. My entry was filed with the clerk at 8:40 this morning. I move for leave to be heard before the court executes that order." Julian Whitmore was on his feet before she finished the sentence. He said her appearance was improper, prejudicial, and staged for exactly the effect it was having. He said she was the named beneficiary of the instrument at the center of the case, that she could not be both the alleged recipient of $180 million and the advocate defending the man who allegedly gave it to her, and that her presence at that table was not a legal strategy, but a piece of theater. Judge Prescott let him finish. Then she looked at the woman standing at the bar with a briefcase and asked her what was in it. "The originals," Willa said. The pen came off the page. She opened with the trust. Not a copy. The original instrument filed in Baltimore City 15 years earlier in a manila envelope with a clerk's stamp across the seal, and she walked it to the bench herself. It was 3 pages. The plaintiffs had submitted 2. The corpus of the trust in the original was $100. It had been $100 on the day it was filed, and it was $100 now. And Willa put 15 years of annual renewal certificates on the screen, one after another, each one filed by the same hand, each one confirming the same figure. None of them ever amended. She said the plaintiff's theory required that $180 million had moved into this instrument. She said the instrument had never held more than $100, and that no court in the state needed a forensic accountant to understand the difference between the 2 numbers. Whitmore was ready for that, and this was where he showed what he was. He did not dispute the corpus. He conceded it. He stood up and said that, of course, the trust was empty. That was the entire design, that an empty vessel is the only kind worth having, and that the money had never needed to rest in the trust. It had needed only to move through the entities the trust controlled. He asked the court to note that the defendant's counsel had just spent 11 minutes proving a point the plaintiffs had never contested. Then he asked where the original had been for 19 days, and who had held it, and whether the defendant's counsel could establish an unbroken chain of custody for a document she had personally carried into a courtroom in a briefcase. Willa could not. Not that afternoon. Judge Prescott ruled that the original would be admitted provisionally subject to authentication, and that the trust corpus alone did not defeat the plaintiff's theory of flow-through. The first round went to the plaintiffs on points, and everyone in that room knew it. She came back the next morning with a letter. It was handwritten on lined paper dated 15 years earlier, and it was 2 paragraphs long. It said that if anything ever happened to the man who wrote it, there would be one document in the world with her name on it that no one could argue with, and that it would not be worth any money, and that this was on purpose because money was the thing people took. She read it into the record in a voice with nothing in it. Then she called June Holloway. June had been the company's legal secretary for 15 years and the keeper of its original documents for 13, and she testified for 40 minutes about the filing room in the terminal basement, the logbook, the renewal calendar, and the $200 a man had paid her in a storefront office in Highlandtown to build the strangest empty container she had ever seen. Whitmore rose to cross-examine, and he asked June Holloway exactly 3 questions. He asked whether she had personally witnessed the defendant sign each of the 41 authorizations in evidence. She had not. He asked whether the filing room in the basement was accessible to any executive with a master key. It was. And then he asked whether she had on the 17th of February met with a representative of the plaintiffs at a diner on Eastern Avenue. June said that she had. The courtroom moved. Whitmore produced a memorandum of that meeting signed by June Holloway in which she confirmed that she could not personally attest to the authenticity of the signatures on the transfer authorizations and could not rule out that documents had left her filing room without her knowledge. He asked whether that was her signature. "It is," June said. He asked whether she had read it before she signed it. She did not answer for what felt from the gallery like a very long time. Then she said that she had been told it was a routine acknowledgement, that she had been told there would be a subpoena either way, that she had been in that diner for 20 minutes, and that she had signed a piece of paper she had not read to the last line. The witness who was supposed to be the spine of the defense had just handed the plaintiffs a document undercutting every original in the building. June Holloway looked at Mason from the stand for 1 second, and Mason looked back and gave her the smallest nod a man can give, and that was somehow the worst moment of the whole hearing. Willa put up the financial transactions anyway. 11 months of them between Barton Kingsley's chairman's office and Van Dorn Meridian Advisory retainers, a consulting arrangement, a corridor study nobody had commissioned. She put up internal email in which the chairman's office had, on grounds of efficiency, rerouted document approvals away from the founder. It was damaging. It was not dispositive. Whitmore called it what it was: governance ordinary, unlovely, and legal. And then, because the round was his, and he intended to end it, standing on somebody's throat, Julian Whitmore turned to the woman at the defense table and asked the court to consider the credibility of counsel herself. He said she had disappeared for 19 days at the moment of her father's greatest need. He said she had been separated from her firm on the 11th and had told no one. He said there was a photograph, time-stamped, of where she had gone instead. He said the court was being asked to accept as an officer of the court a person who had been picked up off a street with no verifiable identity, no verifiable history, and no verifiable name, and who had walked out of the buyer's lobby 9 days before this hearing began. He asked what she had gone there to sell. Willa Brooks Calder stood up. She said her name. She said the name of the street she had slept on. She said the number of nights she had slept there, 11, and the date the state had stopped being responsible for her, and the fact that no one had come, and that nobody was obligated to, and that she had never once pretended otherwise. She said the photograph was real. She said she had gone to the offices of Van Dorn Meridian on the 19th of February because Cassandra Van Dorn had summoned her there, and that she had gone because she wanted it on the record in a building full of cameras that she had walked in and walked out. Then she put the offer into evidence. It was a term sheet. 8 figures structured over 4 years, contingent on one thing only: that she declined to enter an appearance in the matter and remain unavailable through its resolution. It was not signed. There was a signature line with her name typed beneath it, and nothing above it. And there never would be. She said she had spent 19 days not hiding. She had spent 19 days getting a filing room's worth of originals authenticated, a fund's term sheet documented, and a chairman's signature record pulled because a lawyer walks into a courtroom with paper, or she does not walk in at all. She had also been forced out of her firm on the 11th over a conflict she had declined to resolve in the direction the partners preferred. She said she had not told her father because a man about to be cross-examined should not be carrying anything he might be asked about. Whitmore objected on relevance, and Judge Prescott overruled him, and there was, for the first time in 5 days, no sound at all in courtroom 6. Then Willa Brooks Calder turned to the last folder in the briefcase. She said the plaintiffs had submitted a 2-page trust instrument. She said the original was 3 pages, and that this was not an accident of their filing, but a limitation of their research. The county register had digitized its records 11 years ago. The scanning contract had covered typed pages only. The 3rd page of that instrument was handwritten, and so it had never been digitized at all. It had been shot to microfilm, indexed under the file number, and left in a cabinet on the 4th floor of the register's office, where it had sat for 15 years, and where the request log showed it had been pulled exactly once. By her. On the 22nd of February, the plaintiffs had built their entire case on a document they had ordered from a database. They had never once gone to the building and asked for the file. She read the clause. It provided that, in the event any member of the company's board of directors used the founder's family or any instrument bearing the founder's family name as an instrument of a hostile acquisition of Calder Harbor and Rail, the founder's voting shares would transfer immediately and irrevocably to the protector of the trust. The protector had been designated on the day of filing. Then she put up the last exhibit. It was a board consent item dated 6 years earlier, one page ratifying and reaffirming all standing family instruments of the founder routine tabbed flagged, and at the bottom of it, in silver pen script, was the signature of the chairman of the board. Barton Kingsley had signed it himself. He never read it to the last line, Willa said. And she finally turned and looked at her father. Judge Eleanor Prescott did not rule that afternoon. She took the third page of the trust instrument, the register's microfilm certification, the board consent item with the chairman's silver pen signature on it, and the unsigned term sheet from Van Dorn Meridian, and she recessed the matter for 72 hours pending review. She instructed both parties that nothing said outside her courtroom would improve their position inside it, and she looked at the gallery when she said it. In those 72 hours, the case stopped being about a founder and started being about a chairman. The court's forensic review did what June Holloway's filing room could not do alone. The 41 transfer authorizations bearing Mason Calder's signature had all been generated inside the chairman's document queue. Every one of them had been assembled from signature blocks lifted off the consolidated packet of genuine consent items that Wendell Frost had been ordered to compile in September, the same September in which he had been told to disable version logging for 9 weeks. Frost offered immunity on the second day, gave the court everything. He had been paid a retainer through the same one-employee consultancy that had carried the payments from Van Dorn Meridian, and he had kept every instruction he was ever given because a records contractor who does not keep records does not stay in business. The internal email made the sequence plain. And in November, Barton Kingsley had written a single line to Cassandra Van Dorn that the court would quote 3 separate times in its ruling. It said, "The family angle is the whole case. Without it, we have an accounting dispute. With it, we have a monster." The financial trail closed the circle. Advisory retainers routed through a consultancy with one employee, a corridor study nobody had commissioned. Payments that began in the same month the document queue was created and stopped in the same week the lawsuit was filed. And on the 19th of February, an 8-figure term sheet drafted to buy the silence of the one lawyer in the country who could read the instrument at the center of the case. Julian Whitmore requested a private conference with the bench on the second morning. It was denied. Mason spent those 3 days at the terminal. He was not permitted to run the company. The emergency motion had not been decided, and until it was, he was a man with an office he could sit in and nothing he was allowed to sign. So he went down to the loading floor at 6 in the morning, the way he had for 15 years, and he stood at the dispatch window and watched his people work, 1,100 jobs, a retirement plan that had lost half its value in 9 trading days. 4 customers gone. Whatever the judge decided, some of that was never coming back. Gavin came and stood beside him on the second morning. Neither of them said anything for a while. "I told her she'd taken the money," Gavin finally said. "I said it out loud. In the office. To you." Mason kept his eyes on the floor below where a chain gang was setting a container onto a chassis. "You said what everyone in Baltimore was saying. That's not an excuse." "No," Mason agreed. "It isn't." Gavin turned to look at his father, and his father did not turn to look back, and the older man's voice was flat and low and completely without cruelty. "She read every contract this company ever signed," Mason said. "You never did. That's not a failure of character, son. It's a failure of attention. And it's the exact thing they were counting on. Judge Eleanor Prescott read her ruling for 51 minutes. She denied the emergency motion in its entirety. She found that the shareholder derivative action had been brought not to remedy a harm to Calder Harbor and Rail, but to manufacture one, and that the plaintiff's documentary case rested on instruments that the court found by clear and convincing evidence to have been fabricated inside the chairman's own office. She dismissed every claim against Mason Calder with prejudice. She referred Barton Kingsley to the United States Attorney for the District of Maryland and to the Securities and Exchange Commission for fabrication of corporate instruments, breach of fiduciary duty, and conspiracy to effect an unlawful acquisition. She referred the term sheet from Van Dorn Meridian for review as an attempted obstruction, and she ordered Julian Whitmore's conduct in the matter referred to the State Bar's Grievance Commission. And then, in the last 4 minutes, she addressed the trust. She said the third page was valid, that it had been publicly filed for 15 years, that it had been ratified by board consent 6 years earlier, and that the triggering condition had been met by the plaintiff's own conduct in this very proceeding. She said the transfer of the founder's voting shares to the protector of the trust had occurred by operation of the instrument itself at the moment the lawsuit was filed, and that no order of hers was required to accomplish it. Willa Brooks Calder had controlled the company since the 9th of February. Barton Kingsley was suspended by the board the same afternoon and resigned before the vote could be recorded. Van Dorn Meridian withdrew its corridor bid within a week. The fund's limited partners forced Cassandra Van Dorn out inside a month, and the terminals in Norfolk and the warehouse network outside Chicago were sold off in pieces, which is what happens to a collection of expensive parts when the machine they were built around refuses to be bought. Julian Whitmore withdrew from the matter and 3 months later from practice. None of that repaired anything. The company came back to Mason smaller than it had been. 2 of the 4 suspended customers never returned. The rail spur agreement, which had taken him 6 years to win, was renegotiated on terms that cost the company its margin on the northern corridor. And in June, the board voted to sell the Pennsylvania interest outright to cover the shortfall. Mason voted for the sale himself. It was the first time in 15 years he had voted to break off a piece of the thing he had built, and he did it because 1,100 paychecks were worth more to him than a promise about a map. The valuation when it settled was $640 million. Nearly a third of the company was simply gone. He restructured what was left. Gavin was put in charge of operations, which meant the terminals, the yards, the dispatch floor, and the 1,100 people on it, the part of the company that had actual weight, and the part his father had never once been willing to hand to anyone. Gavin took it, and every contract that crossed his desk, he read all the way through, and he was still doing it a year later, when nobody was checking anymore. Willa did not take a title in the company. She transferred the founder's voting shares back into the operating structure within 90 days under a governance framework she wrote herself, and she kept exactly one thing: the trust. It was renamed the Founders Trust. Its corpus was raised from $100 to a working endowment, and its mandate was written in language that no board would ever be able to root around. It existed to protect the company's core commitments, that the terminals would not be broken up and sold, and that the people who worked them would not be traded as a line item. Willa Brooks Calder became its general counsel. Her salary was paid by the trust, not the company, so that she could never be removed by anyone she might one day have to sue. She had, after all, already been removed once for reading something too carefully. In September, they held the all-hands meeting on the pier, not in the auditorium downtown. Mason had it set on berth 4 on the container pier, where he had worked chains for 11 years before he ever rented a garage, with the crane stopped and the gantry lights on, and 1,100 people standing on the concrete in work vests and safety boots, and here and there a suit that looked wrong on the person wearing it. He did not use a podium. He used a shipping pallet and a hand microphone that popped every time the wind came off the water. He told them the number first because he thought they had earned it before they earned anything else. $640 million. He told them the company was a third smaller than it had been in January, and that the Pennsylvania interest was gone, and that some of what had been lost was not coming back, and he did not dress any of it in a better word. Then he told them about a bus shelter on Browning Highway. He kept it short. A shift that ended at 11. A rain that had been going all day. A young woman on a bench with a canvas bag between her ankles who did not ask him for money. He said he had walked her to a police station and sat in a plastic chair for 2 hours and asked what the legal path was and had been told there wasn't one, because once you were of age, you were nobody's problem. He said that he had spent 15 years building a company on the theory that the sergeant had been wrong about that. They used it against me, he said. In that courtroom, the best thing I ever did was the whole case. A man stood up in front of a judge and said I hadn't taken in a daughter, I'd incorporated one. And for a while, everybody in this city believed him, including some of you. I'm not going to pretend I didn't hear it. Nobody moved on the concrete. Here's what I want you to take back to your yards. This company did not survive because I had good lawyers. It survived because 15 years ago, I paid $200 I didn't have to a paralegal in Highlandtown, so that one person in this world would have a piece of paper with her name on it that nobody could argue with. That was not strategy. That was not a hedge. It was a Tuesday, and it was the decent thing. And I forgot about it inside of a year. He looked out at them. Decency doesn't pay in the quarter you spend it. Sometimes it doesn't pay for 15 years, but it's the only thing I've ever put into this company that they couldn't fabricate, couldn't buy, and couldn't route around a chairman's desk. Everything else on this pier has a price. That didn't. The applause took a while to start the way it does when people are working out whether they are allowed to. Afterward, the crowd thinned into the parking apron, and the crane started up again, and Mason stood at the edge of berth 4, with his coat open and the water going gray behind him. Willa came and stood beside him. She had her briefcase because she always had it now, and she set it down on the concrete. You had the shares from the day they filed, Mason said. The 9th of February. You could have stopped all of it in a week. I could have stopped the motion, she said. Not the men. If I had walked in on the 10th with that clause Barton resigns quietly, Van Dorn walks away with clean hands, and both of them come back for you in 18 months, with a better lawyer and no paper trail. I needed them to build the whole thing in front of a judge and put their names on it. It cost the company a third of itself. Yes, she said it without any softening at all, and she did not look away from the water when she said it. And Mason understood that she had done that arithmetic long before he had, and had made herself live with the answer. You let them call me a monster on television, he said. For 19 days. I let them say it under oath. That's the only place it could ever be taken back. She finally turned to him. You were never in danger of losing this company, Dad. You were in danger of getting it back with them still inside it. I wasn't going to hand you that. Then she reached into her coat pocket and took something out. It was a key. Brass worn down to a dull yellow at the bit the teeth rounded off from 15 years of a lock on Dillon Street. I've carried it every day since you closed my hand around it, she said. Through law school, through the firm, through 19 days with a photograph of me walking out of that lobby on every screen in Baltimore. I never took it off me. Not once. She turned it over in her palm. You told me nobody gets left out in the rain, and you told me never to sign anything I hadn't read to the last line. I spent 15 years thinking those were 2 different lessons. They're the same one. You read to the last line, because that's where they hide the part where somebody gets left outside. She put the worn key back in her pocket. Then she reached into the other pocket and took out a second key, new, still bright cut from a blank that morning, and she pressed it into her father's hand and closed his fingers over it, exactly the way he had once closed hers. Dillon Street stays in the family, she said. The trust bought it in June. It's not going to be sold, and it's not going to be lived in by us." She held his hand shut around the metal for a moment longer. "Whoever's out there at 11 o'clock on a rainy night with nowhere to go, that's whose house it is now. There'll be a bed in it, and a lock, and their own key. That's what the endowment is for. That's the entire mandate." Mason looked down at his closed fist for a long moment. He had built a $900 million company and had it cut to $640. He had been called a monster on every station in the Mid-Atlantic. He had stood on a witness stand and said, "Yes, I did," in front of a room that had already decided what he was. He had not once, through any of it, needed to be told what to feel. He opened his hand and looked at the key, and then he closed it again, and he did not trust himself to say anything at all. Behind them, the gantry crane swung out over the water, and it started very lightly to rain. 15 years earlier, a man with $41 in his checking account had sat down on a wet bench beside a stranger because she moved over to make room for him. He had not been building anything. He had not been buying insurance against a boardroom he could not yet imagine. He had simply refused to walk past. That refusal had sat in a cabinet on the 4th floor of the county register for 15 years in a document worth $100 waiting, and when everything else he owned had been taken from him, his name, his company, his own signature turned into a weapon. In another man's hand, the only thing left standing was the promise he had made and kept, and the woman who had read it all the way to the last line.